Well, welcome back, everyone, after our break. It's my privilege to be moderating panel 5, which is entitled Curtailing the Global Arms Trade and Promoting Common Security. We have two very capable speakers. In the tradition of the others, I'll just be very, very brief. You see in the bio, Alex Neve is an adjunct professor in international human rights at the University of Ottawa. And of course, many of us know him in his position as Secretary General of Amnesty International Canada, English branch from 2000 to 2020. And of course, what many of us know him as an indefatigable champion of human rights in Canada and internationally. He's on my right and on my left, Robin Collins, a longtime colleague and friend. He is secretary of the Canadian Pugwash Group, one of the 3 sponsoring organizations of this event. I'm proud to say he's a Rideau Institute board member. He's one of the immediate past co-chairs of the Canadian Network for the Abolition of Nuclear Weapons. And so we have 2 speakers who are very well qualified to talk to us on this topic today. Alex is going to start, and he will speak first, focusing on the Arms Trade Treaty, a mechanism that is not working effectively. I would say in large part because of our current international security system with all the negative characteristics of great power competition, zero-sum approaches, and out-of-control arms racing that we've been discussing today. Robin will then discuss elements of a possible alternative common security framework. So I turn first to Alex.
And you should have given a spoiler alert, Peggy. You've given away my I'm sure everyone was going to be on the edges of their seat wondering if the arms trade treaty is working or not, and you've spoiled the fun. So 3:15, the middle of the afternoon, it's been a full and intense day, obviously heavy and important topics. And I'm the optimistic guy who gets to talk to you about the arms trade treaty. I want to start by taking you to the ground. I really want us to focus in on lives and how they're impacted by what I'm going to be talking about with respect to the Arms Trade Treaty. And a lot of my work, especially a lot of the years of Amnesty International missions around the world, certainly repeatedly brought me up close and personal to that devastating impact. My first encounter with interviewing the survivors of widespread and indiscriminate bombardment, and then later, sometimes even later in the same day, documenting the weapons and ammunition that had rained down on their homes, markets, and communities within remote villages across eastern Chad along the border with Sudan's Darfur region back in 2006. And the deaths, the injuries, the destruction were numbingly awful. And the numbers of bullet casings in particular, I can see them even kind of sparkling in the desert sun, that littered those villages were nothing short of obscene. Next, I think of crowded neighborhoods, markets, and even a mosque in the Chadian capital of N'Djamena in 2008, caught in the crossfire of urban fighting between the military and a rebel group. Back to Eastern Chad in 2009, 2010, 2013, in Côte d'Ivoire's capital, Abidjan, and in villages throughout central and western Côte d'Ivoire in 2011 and 2012, isolated corners of the Nuba Mountains in Sudan's southern Kordofan region in 2013 and 2015, where shells littered the grounds of a hospital. And I spent time huddling in caves, interviewing children who were hiding there from the bombs. Neighborhoods throughout Juba in South Sudan in 2014. And this list could go on and on. I think of being in Colombia in 2016, Myanmar, 2019, Northeast Syria last year. Words do not come close to capturing the horror and the sorrow of visiting a home incinerated beyond recognition in which an entire family had been killed, of sitting with a woman so badly injured when a rocket destroyed her home that her 2 legs had been amputated below her knees, of touring the grounds of a school hit by dozens of rockets where terrified students had rushed to hide in the numerous shelters that they themselves had dug around the schoolyard for precisely this possibility. The school building itself, with nothing left standing, and charred and battered desks, workbooks, and blackboards strewn far beyond the school premises. Of visiting a hospital, bombed while the only doctor there was in the operating theater treating victims maimed by previous bombs. And of walking through a market area hit and set ablaze by artillery shells with body parts and bits of clothing still visible on the ground and even in the trees. And words certainly do not capture the disbelief and the anger of seeing the desperate shallow bomb shelters that people had dug into dry, rocky ground and watched as they demonstrated to me how many people could cram in and even pile on top of each other to stay safe, or of measuring the depth and breadth of massive bomb craters just outside a camp for internally displaced people, so deep that as I stood in the middle with my arms stretched over my head, I couldn't even come close to the lip. Of taking up-close photos of the bullet which doctors had removed from the upper chest of a prominent opposition politician only centimeters above his heart. Of carefully examining unexploded rockets, nose down, unexploded, half buried on the grounds of a hospital. Of picking up the twisted bits and pieces, larger fragments, or even nearly intact remnants of rockets, artillery shells, cluster munitions, bombs, and bullets from people's homes, fields, and marketplaces. Of being shown small slivers of an armed drone shot down, but only after it had already struck a car carrying a journalist and her driver with deadly precision. And of looking for the writing, the numbers, the symbols that would confirm what was already abundantly clear, that these tools of death came from the United States, from Russia, including leftovers from the days of the Soviet Union, from China, from Israel, from Germany, Ukraine, France, Belgium, Turkey, Spain, from so many countries, even in my own limited work, that I cannot begin to remember them all. The dystopian reality of it all is that in none of those schoolyards, homes, markets, or hospitals did any of the arms and weapons used to kill, maim, terrorize, and destroy come from production lines in that country where lives were being obliterated. Rather, they all came from other corners of the world, thousands of kilometers away often, and they were sold, brokered, transferred, smuggled, stolen, shipped, or just handed over to militaries, governments, armed groups, terrorist cells, and other groups and forces for whom the safety of civilians was not only not a concern, but more often than not, a brutal, callous, deliberate tactic. Well, nothing could be a more visceral indictment of the global arms trade. And nothing more powerfully made the case for why an arms trade treaty was so desperately needed. I was often asked by survivors or by neighbors who had gathered up the body parts of friends and family, what would it take to make it stop? And while I was on the ground, I often met with local groups who were focused on doing something about the deadly impact of those arms and weapons in their country. I think of the Association Tchadienne des Survivants d'Atrocités et des Crimes de Guerre. I think of the Organization of War Widows and Orphans in South Sudan, the Council of Martyrs' Families in Northeast Syria. What they all were essentially looking for were rules, simple rules that would keep those arms out of the hands of forces intent on committing those atrocities against them and their loved ones. And their plea was heard, and their demand prevailed. But you've already heard Peggy's spoiler. Their demand prevailed in theory. Amnesty International was one of the many, many organizations that took up the cause. Others are here in the room, certainly Project Plowshares, joining the Control Arms Coalition, alongside several hundred other organizations, so many of whom were working at the grassroots level to address the ravages of small arms and light weapons. I was Secretary General here in Canada for Amnesty in those days. Control Arms, as many of you will recall, I'm sure many of you took part, gathered over 1 million signatures through its famous Million Faces petition campaign. And we had campaign events using pictures of bananas, as Cesar reminded us this morning, to make that absurd point that the banana trade was more regulated around the world than the arms trade. And every time I spoke about or promoted the campaign, the faces that were front and center for me were those faces from Chad, from Côte d'Ivoire, and other frontline communities. And of course, we succeeded against considerable odds. And on April the 2nd, 2013, the Arms Trade Treaty was adopted overwhelmingly by the UN General Assembly. 154 states, including Canada, asterisk, without much enthusiasm or leadership, back to that in a moment, voted in favor. Only 3 voted against it at the time: North Korea, Iran, and Syria. Need we say more? And there were 23 abstentions. Now, those voting in favor at the time included a number of key arms producing and transferring countries. Even the United States voted yes in 2013. Russia and China both abstained. Then, and I know a lot of you know this, but the race was on to encourage 50 states to ratify the treaty, because that was the threshold we needed to reach in order for the treaty to enter into force. And within 18 months, and UN speed, that's relatively fast, that threshold had been reached. The 50th ratification came on September the 25th, 2014. In fact, Argentina, Bahamas, Bosnia and Herzegovina, the Czech Republic, Portugal, St. Lucia, Senegal, and Uruguay all ratified on the same day. So we had numbers 46 through 53, all kind of collectively got us across the finish line. And 90 days later, the ATT entered into force, December the 24th, 2014. 2014, December, so think about it, we're on the cusp of a decade now. This was not Canada's proudest moment. The country that had led, I'm struck by how often I've been saying that lately around a number of topics, not Canada's proudest moment. The country that had led the world when it came to banning landmines, of course, only 18 years earlier, leading to the 1997 Ottawa Treaty, was not among that first group of 53 states party. We were not even among the first 100 states to become party to the ATT. We didn't do so until June 19th, 2019, over 6 years after the treaty had opened for signature, becoming the 104th state party. That will never be anything to boast about. The treaty entered into force for Canada on September the 17th, 2019. Now, I'm not going to go into the politics as much as I'd like to as to what stood in the way of Canada getting on board the ATT earlier and more enthusiastically. Suffice it to say that at the time, Stephen Harper's government clearly made a decision that there was more political advantage to staying out of the treaty and taking groundless pot shots at it than showing some meaningful international leadership. 11 years since the ATT was open for signature, there are now 116 states party. So there hasn't been a lot of action since Canada. Remember, Canada's 104. We're only at 116 now. The most recent actually just came last week. Colombia is on board. The United States and Israel, perhaps surprisingly, have actually signed the treaty, but not ratified it, and no one would be insane enough to imagine that's going to happen. China's a party. Russia is not. The heart of the treaty, of course, lies in Articles 6 and 7. And I know many here know these provisions well, but it's worth just briefly reiterating what those articles stand for. Article 6 is an absolute prohibition on arms transfers in certain circumstances, and that includes when the state doing the transferring has knowledge that the weapons or arms would be used to commit genocide, crimes against humanity, or war crimes. Article 7, and this is really where, in many respects, the rubber hits the road. It obliges a state to, quote, assess the potential that the arms could, among other concerns, be used to commit serious violations of international humanitarian law or international human rights law. Then, considering that potential alongside any mitigating measures that might reduce the risk, if it is determined that there is an overriding risk of serious violations, the transfer is to be prohibited. Notably, states are also directed to pay particular attention to the potential that the arms may be used to commit serious acts of gender-based violence or serious acts of violence against women and children. So Canada, slow to get there, we got there. So in 2019, alongside becoming a party, we amended our Export and Import Permits Act to ensure compliance with these ATT obligations. So we're a party, we've amended our law to meet the obligations. The key question, how are we doing? Well, for years, the litmus test has been Canada's multi-billion-dollar deal to sell armored vehicles to Saudi Arabia, and there's probably no one in the room who's not familiar with that. Human rights groups, UN experts, legal scholars have been opposed to arms transfers from any country to the Saudis because of Saudi Arabia's role in the civil war in Yemen. And clear, documented proof that Saudi coalition forces were repeatedly, not just once, repeatedly responsible for widespread war crimes in Yemen. The contract, announced in 2013, constitutes the largest arms deal in Canadian history, $14 billion in value for the sale of 742 armored vehicles, 652 of which have been transferred to date, including 40 last year. By any measure, this deal should not have been allowed to proceed, certainly once Canada was bound by the ATT. Notably, so even though it was already out of the starting blocks by the time we'd signed on to the ATT includes an obligation for ongoing reassessments as more information comes to light, et cetera. So it's not that you just make a decision once, park it, and never come back to it. Instead, though, it has been business as usual with a host of excuses, including the value of the direct and spin-off jobs created at the General Dynamics plant in London, Ontario, or the excessive financial penalty for canceling the contract, or the importance, apparently, of countries knowing that a contract with Canada would always be honored. Apparently, that's more important than countries knowing that Canada will always honor its treaty obligations. Or Canada's strategic geopolitical and security relationships with Saudi Arabia, or the fact that there had yet not been any direct evidence, documented pictures of a General Dynamics armored vehicle manufactured under that exact specific contract being used to commit violations on the ground in Yemen. None of that changes the fact that there is clearly authoritative evidence of a substantial risk which has not been mitigated, that the armored vehicles transferred to Saudi Arabia would be used to commit serious humanitarian and human rights law violations. Hard to categorize this, therefore, as anything other than a blatant failure to live up to our ATT obligations. Another case study, Turkey. Here, the issue has been $300 million worth of Canadian-made surveillance and targeting sensors used to guide smart munitions to Turkey. The concern is that Turkey has either used or diverted those sensors to Azerbaijan, Libya, and Syria. The diversion of those sensors by Turkey to Azerbaijan, used against Armenians in the enclave of Nagorno-Karabakh, led Canada to suspend the permits in 2020 and then cancel them in 2021. Thumbs up. So far, so good. Not the end of the story. That was reversed in January of this year. And it's pretty clear that isn't because human rights had broken out and there was no longer any reason to be concerned. No, it was all about the wider geopolitics of getting Turkey to agree to Sweden's accession to NATO. Project Plowshares, kudos, has reported extensively on this and convincingly laid out the deficiencies in the decision to restore authorization for those transfers to Turkey, but the decision stands. And then there is Israel. $30.6 million worth of arms transfers in 2023, the highest value of arms sales from Canada to Israel ever. Obviously, there's been considerable pressure on Canada to stop all arms transfers to Israel at this time, and that began to mount immediately in the weeks after October the 7th, as the staggering, unprecedented scale of Israel's military operations in Gaza became clear. Evidence of war crimes mounted rapidly, and soon researchers, UN experts, and scholars were, of course, pointing to the likelihood that genocide was occurring in Gaza, all of which was reinforced with the ICJ's ruling at the end of January that Israel's obligations under the Genocide Convention were plausibly engaged by its operations in Gaza. So what's played out here? On January the 7th, the Canadian government announced that there would be no new permits, note that word, new permits, issued for arms sales to Israel. That did not, however, immediately impact approximately 210 permits that had already been issued and were still active, which were estimated to be in the range of $136 million. Doesn't sound like much of an arms embargo. Now, to give them credit, 30 of those permits have subsequently been suspended. That was announced this past summer, but we're still not where we need to be. And then, of course, the other major problem arises through what is often termed the US loophole in Canada's arms regime. It's long been estimated that on average, there are around $2 billion worth of Canadian arms transfers to the United States every year, mostly parts and components, which are then assembled into weapons and arms in the United States. And that's around 50% of Canada's arms sales. But they are exempted from the export regime, which assesses and upholds our ATT obligations. And I would challenge anyone to find a provision in the Arms Trade Treaty that says you're allowed or you can do that in any way, shape, or form. Many of us pushed hard when Canada's ATT implementing legislation was going through Parliament in 2019 for that gaping hole in our arms control regime to be closed, to no avail. Notably, last month, and it is notable because I don't know if I can go so far as to say this has never happened, but it's hardly ever happened. Minister Joly did announce that the government was suspending a contract by which the Quebec division of US company General Dynamics would be supplying ammunition that would go through the United States and on to Israel. So it's a US loophole case that was suspended. So thumbs up for that. But Canadian sales to the US of components being used to assemble F-35 fighter jets in the United States for transfer to Israel appear to be untouched, protected by the US loophole. Notably, there is litigation underway in the Netherlands, where a number of groups, including Oxfam, are challenging kind of the Dutch equivalent. They're challenging the fact that the Dutch government continues to authorize F-35 parts to be sold to the United States, destined eventually for Israel, even though there was an earlier court ruling that banned Dutch-made F-35 parts being transferred directly from the Netherlands to Israel. It'll be interesting to watch that case. So let me wrap up. Where to now? Well, we just marked last month, in fact, the 5th anniversary of Canada's accession to the Arms Trade Treaty and those statutory reforms that supposedly enacted to implement our obligations under the treaty. The track record since, just considering that combination of Saudi Arabia, Turkey, Israel, and the United States is, to put it mildly, not particularly impressive. And of course, the common thread there is that when it's about allies and when other geopolitical imperatives are in the frame, funny thing, but the ATT just seems to fade into the background. With all 4 countries, the case for why permits either remain in force or were restored is flawed and problematic and flies in the face of documented evidence from the ground. The situation with Israel highlights the fact that the US loophole is untenable and blatantly circumvents and ignores our treaty obligations. It needs to be closed. So it is, I would suggest, time for a thorough review of the state of Canada's ATT compliance. 5 years on, that's kind of one of those things we do, eh? 5-year reviews are quite commonplace. Well, why not? For our relationship with the ATT, an opportunity to identify areas in need of strengthening and reform. But let's think about the political context. Obviously, the best chance of doing so would be now, before any possible change in government. What might modalities be? Well, it could be taken up by a parliamentary committee. These days, parliamentary committees, they're a little bit more partisan than thorough in a lot of their work, but that's an option. Could perhaps also be taken up, this is probably dreaming, but by the government appointing an independent expert group of some kind to carry out a review. If that was to happen, the runway for doing so is increasingly short, looking ahead to these ever-shifting political context in Canada, but it's something to consider. The bottom line is, though, we can and we must do better, and I know that all of us in this room will continue to do everything we can to make sure we keep moving in that direction. Thank you.
Thank you. Thank you very much, Alex. And just on a tiny positive note, each of those changes to the current government pattern of exports to Israel since October 7, each of the changes somewhat curtailing those exports were preceded by massive public pressure led by a range of non-governmental organizations and appealing directly to the public as well. So a positive
People
note there.
power matters.
Yes, it does. It does. Especially when there's pressure on the other side, as we know there is. And so, Robin, you're on.
Alan.
Yes, you're on.
And half of those organizations are in this room, I believe. Well, so this is a bit of a warm-up on a topic some of us have been working on for a while, that is primarily common securities, but I'm going to be talking about. And so you're my all right, you're my test audience. Now you'll find, those of you who know the topic fairly well, that some of this material sounds awfully old. That's because a lot of this stuff is old. It came from a few decades ago, and we're hoping that it will be revitalized now. So I've subtitled my presentation with this question, which I hope I can partly answer, or at least you think I might have answered it by the end. That being, can we eliminate nuclear weapons while retaining our current competitive security arrangements? The Pomig Commission in 1982 proposed a new security concept in its report, Common Security, a Program for Disarmament. It was stated briefly this way: all states, even the most powerful, are dependent in the end upon the good sense and restraint of other nations. Even ideological and political opponents have a shared interest in survival. 40 years later, 2 years ago, in 2022, the updated Common Security Report called For Our Shared Future distinguishes itself from the original with reference to what has changed in 4 decades. More attention, they said, should be given to technological change, including space and autonomous weapons and hypersonic missiles, to climate change, to gender equality issues, and to broader involvement of civil society. While acknowledging these modest adjustments, the earlier 1982 program was the more significant, in my opinion, and the breakthrough statement. So to start with, I want to begin with 4 points about common security. Clarifications, really. 1, common security is not in itself a pacifist project. While it inclines us towards the reduction of violence and to limits on use of force, because the guidance is international law, bad news for some, therefore there is also enforcement. There is peacekeeping. There also could be a UN Emergency Peace Service, UNEPS, what many of us do advocate for. But the priority is prevention of war and violence through conflict mediation measures such as diplomacy, the UN or other good offices, ending threatening postures, an item I'll highlight later, and pressing for arms reductions. Therefore, it is also true to say that the focus is on peaceful measures that reduce and undermine conflict. This is peace advocacy, if not pacifism. Second point, common security is not a destination, but a process and a practice. We do not need a fully fledged common security framework in place to remove certain categories of weapons or to change provocative defense postures. The global systems we move through over time will inherently be imperfect, and there will be relapses and backsliding. 3, disappointing to some, the end of capitalism is not a prerequisite for common security. An essential assumption of common security is that it can develop despite economic and political system differences, democracies and dictatorships, even while reduction of global poverty is a goal. If we must wait for an agreeable, perfect future system, we will be waiting in vain, and more time will pass than we can afford to address our global crises. Things can move quickly or slowly, but we will need to take sequential steps. Common security is very much a child of the Cold War and was originally designed to reduce the risks of conflict and nuclear war between the US and the Soviet Union. That is why, with the end of the Cold War, the term, if not the practice of common security, seemed to disappear from diplomacy, and shame on us, also the priorities of much of the peace movement. This is also why some ideas of the 1980s have resurfaced now, why there's a new common security report, due to rising tensions. But the essential elements were never dependent on Cold War contention. Rather, they are and were rational, arguably neo-realist, timeless ideas pertaining to conflict resolution, preventing war, including nuclear war, and arms control and disarmament. And the fourth point, balance, stability, and détente are not in themselves common security. Balance, stability, and détente are not common security. They are elements of it, but they are not it. This is a particularly important point because it disrupts the belief that nuclear deterrence can simply be replaced by conventional deterrence and all will be well. Deterrence has the failing of freezing in place a status quo which we know as the stable balance of power. But as well, it does not contain an incentive for change. Imbalance can be worse than balance, of course, but the actual goal of deterrence, it might be argued, is to perfect the stability of the stalemate existing in competitive security and not to replace it. For example, mutually assured destruction, MAD, and spheres of influence, even at the cost of turning a blind eye to dictatorship and global inequality, are relatively stable, but also dangerous sources of conflict. Because science and technology inevitably march forward, systems and weapons will need perpetual modernizing by all sides. Older systems wear out and need replacement. That's the argument. And the new ones are superior to those of adversaries, which is true, who will now also update. Result, the classic arms race. Should we outspend our enemies? Or do we allow for weapon reductions that enable the redistribution of funds and human resources elsewhere? And remember also that as leaders change, their replacements are not all going to be rational actors. Some will be thugs. Deterrence theory can erroneously presuppose that failures won't happen that could disrupt the stability. Nuclear and conventional deterrence, therefore, would only be modulated in a way to strengthen and thus reinforce the security dilemma. John Herz in 1950 first coined the term security dilemma. It's an old term. It was used to identify how even states with defensive motivations, seeking only to enhance their own security, inadvertently still end up in conflict due to mutual uncertainties about the intentions of the other. On the nuclear weapons front, the response to this dilemma of uncertainties, however, was not speedier abolition, but possible reductions and non-proliferation measures to put a lid on the nuclear club. The message is nuclear weapons are safe with our P5 hands or in our P5 hands, but not in yours. That argument may not hold for states who are outside looking in. Just this month, Ukraine President Zelensky stated, quote, "What choices do we have? Either Ukraine will have nuclear weapons, which will serve as protection, or it will be part of some kind of alliance," end quote. Did he mean a nuclear alliance? Therefore, for all these reasons, even if nuclear deterrence were relatively stable for a time, it cannot be coherent as a sustainable or sufficient basis for common security. Nuclear deterrence cannot be a basis for common security. Treaties and agreements are beneficial. Parity, rather than lopsidedness, can help. But in practice, as we've seen, the balance of power, stability, parity, and détente are temporary, unstable, and unsustainable, even if we acknowledge that being more stable is still better than being unstable. We are stuck with the reasonable expectation that nation states will still want to protect themselves with weapons and military capabilities, and ideally, and this is a critical point, ideally, if those resources are kept limited and non-threatening to other states. Even to get to that modest, safer stage, however, we will need a transition strategy with clear steps. So what happened to the post-Cold War peace dividend? It seems clear the complacency and Western hubris that followed the end of the Cold War led to disinterest in the ideas brought forward by 1980s common security advocates. Nuclear weapons were reduced but not eliminated. Deterrence doctrines were adjusted but stayed with us. We had a brief peace dividend after 1989, but it was not sustained. How do we get to common security, non-provocative, and non-offensive defense? As Sphere Loggaard, former director of the Peace Research Institute of Oslo, that's PRIO, for those who know the acronyms, argued early on, and I mean early on, quote, the best way of pushing nuclear weapons back to rear positions and down to a minimum level may be to develop alternative means of defense. Non-provocative conventional defense, quote, is easier to achieve than complete disarmament because the military will not be eliminated. Moreover, the concept, quote, does not contradict the celebrated United Nations goal of general and complete disarmament, since the main merit of such a defense posture, that is non-provocative defense, is that the threat function is eliminated. It will also pave the road for disarmament, end quote. Egon Bahr, similar generation of thinker in this area, argued that the doctrine of common security meant that, quote, neither side can gain military advantage that could be put to use without unacceptable risks, end quote. It has built-in restraint if it is to work. By way of verifiable agreements, it can assure military stability and therefore also is an offer of confidence building. But common security cannot be substituted for that of deterrence in a single sweep. It might instead start with the exchange of information and end with quantitative arms limitations and eventual cuts in the common interest. That is not to say unilateral steps are not welcome also. These, as confidence building measures, can send the right messages that invoke matching reductions by others. A complication, however, is that confidence building requires transparency, but security requires secrecy. These are therefore obstacles. Drink that a little bit earlier, actually, but the International Pugwash Conferences were a key forum for East-West discussion of common security and alternative defense during the Cold War, and their workshop discussions were brought to the attention of former Soviet leader Mikhail Gorbachev, who was supportive. As Michael McGuire said in 1996, notice the dates again, in Finland at the 46th Pugwash Conference, Gorbachev was able to make inroads with his new political thinking and crucial reworking of military doctrine precisely because ironically, the USSR wasn't a democracy, and because he therefore wasn't at risk of being outflanked by appeals to national pride. Here we might compare Putin versus Gorbachev. In 1987, I'm not sure if he's still here, but Frank von Hippel, together with Randy Forsberg, were instrumental in encouraging Soviet academics to support non-offensive defense postures. Following their advocacy, Gorbachev would subsequently reduce Soviet troops in Eastern Europe and remove 500 short-range tactical nuclear weapons. This would lead to the Convention on Armed Forces in Europe Treaty, the CFE, in 1990. Then, mutual limitations on major armaments for NATO and the Warsaw Pact, placement of weapons not in service in permanent storage, and creation of systems to resolve compliance issues. Sverre Lodgaard explained how a switch or transarmament towards non-provocative defense means that those weapons having distinctly offensive characteristics must be identified and eliminated. Which ones are those? And then existing forces will be reorganized and deployed in less provocative modes. No easy project. He explained further that the new postures must be unambiguously non-provocative overall, because, this is a quote, single elements may unavoidably have offensive connotations. The challenge, as he knew, is to design gradualist approaches that feed the ideas into the political processes. In their book, Non-Offensive Defense for the 21st Century, Björn Moller and Håkan Weiberg clarified, two Danes, I believe, clarified that NOD, non-offensive defense, eliminates reciprocal fears, rules out preventive and preemptive wars, allows for defensive strengthening during crisis without increasing the threat posture, and unlike nuclear deterrence and MAD, allows for non-suicidal defense options that don't self-deter. Those are complicated concepts, and I highly recommend you look into them deeply. Non-offensive defense has two core assumptions, and this is where I was talking to Branka earlier, are that we distinguish offensive from defensive formations and postures, not necessarily weapons, but where they're placed and how they look. And also that defense is generally inherently stronger than offense because of specialization and the advantages of advanced preparations. Disarmament is not primarily a legal or treaty question. This point emphasizes that although law is important for institutionalizing disarmament, together with its verification and enforcement regimes, disarmament is primarily a security and trust question. This overall humanitarian and ethical framework, as outlined in the UN Charter, contends with the need for national and collective security. For the UN Charter, international cooperation relies on those effective collective measures for the prevention and removal of threats to the peace. The Charter also respects domestic jurisdiction of states except where enforcement measures under Chapter 7 are authorized by the Security Council. This balance is not an end in itself. To succeed, it needs to be part of a process towards both disarmament and shared security. Similarly, arms control is not only agreeing to treaties, but also restrictions, safer methods, and risk reduction. Abolition is something far more demanding and therefore often harder to do. But was the Ottawa Treaty to ban anti-personnel landmines a project that many in this room were directly involved in? Was it hard to do? To answer this question, we should distinguish strategic from peripheral weapons. Weapons that are either seen to have limited utility for strategic deterrence or in war fighting, such as anti-personnel mines, cluster munitions, or chemical and biological weapons, have been removed from arsenals relatively quickly in many countries. That's not arguing that their elimination is irrelevant. Their non-use has huge humanitarian benefits and a measurable impact on casualty numbers, particularly those of civilians. But it must be said that the challenges posed by nuclear weapons, cruise missiles, lethal autonomous weapon systems, space-based and unmanned aerial vehicles or drones are far more complicated to deal with because of their strategic importance. Let's not forget, too, that the consequential 1996 Red Cross report, Anti-Personnel Mines, Friend or Foe, that fundamentally undermined the legitimacy of anti-personnel mines, didn't argue that mines had no military utility. Quite the contrary, but rather this: the limited military utility of anti-personnel mines is far outweighed by the appalling humanitarian consequences of their use in actual conflicts. As well, treaty regimes, including the Ottawa Landmine Treaty, still face outliers and poor countries that are unwilling to give up their stockpiles. Nuclear weapons and missiles for their delivery have been reduced in number. Treaties have been created, such as the NPT and the TPNW, but no comprehensive elimination by key possessors has proceeded. The current rhetoric is, alas, in the opposite directions, as many people have pointed out today. Modernization and increased inventory. China wants to triple its missile count from 500 to 1,500, just to name one case. The Treaty on the Prohibition of Nuclear Weapons is supported by 137 states, about half of whom are state parties, but none that are key. The Model Nuclear Weapons Convention is backburnered, although some nuclear weapons and nuclear umbrella states, including China, India, Pakistan, and North Korea, to name 4, have tentatively supported it in the past. And yet, common security practice can still lead to disarmament successes, and unilateral efforts at disarmament can do the same. We don't know if there exists a definitive future common security in which complete and general disarmament will reign in the future, but that remains the admirable goal we aim for. The way the UN General Assembly defined general and complete disarmament at its first special session on disarmament in 1978 was as the elimination of all weapons of mass destruction, coupled with the balanced reduction of armed forces and conventional armaments based on the principle of undiminished security of the parties, and with a view to promoting and enhancing stability at a lower military level. But also there was an imperative to halt and reverse the nuclear arms race until the total elimination of nuclear weapons and their delivery systems has been achieved, and a call for related negotiations on the limitations of international transfer of conventional weapons. Sounds familiar. In NATO terms, arms control is about stability, is the quote, at the lowest balanced level of forces and armaments consistent with the strategy of deterrence, end quote. The three key words there were stability, balanced, and deterrence, but there was no mention of non-provocation. In contrast, the 1982 Common Security Policy Report described the obstacle and its negation this way: in the long run, no nation state can base its security on the insecurity of others. True security requires a cooperative effort, a partnership in the struggle against war, end quote. To conclude, this disarmament common security relationship is certainly a challenge, and one that takes leadership and persistent political nerve. Perhaps there's a dearth of both presently. Civil society has a recognized role in the transition, therefore. Why there should be disappointment that we dropped the common security ball after the end of the Cold War, after 1989. It is not for naught that the Nobel Peace Prize in 1997 was awarded to the International Campaign to ban landmines and leader Jody Williams, but probably unfairly skipped over Lloyd Axworthy. Same as in 2017 to ICANN, the International Campaign for the Abolition of Nuclear Weapons, for achieving the Treaty on the Prohibition of Nuclear Weapons, and not also Austrian diplomat Alexander Clement. Thus, these we can surmise were significant acknowledgements of civil society participation and collaboration, even if formalized by treaties, obviously requiring governments, officials, and politicians. To realize our goals, we must rely primarily on fact-based information, not just passion, and collate a comprehensive understanding of security, while also keeping our eyes on the prize of a more peaceful world. Most critical, we need to do a better job of twinning the objectives of disarmament and common security if we hope to be successful in fulfilling either. Thank you.
Here, can't get the mic on. Thank you. Thank you two very much. Two very compelling presentations. I have to say, Robin, that I'm going to have to read this text a few times. There's an awful lot in there. And
Find the mistakes?
no, just there's so much in there. And so I want to open the floor now to questions. Okay, I see. Let me just take note. Right. Lady, okay, I'm not, because I don't know people's names, I'm not going to be able to keep everybody's list, but so I'm going to recognize the first two here. And then, so others that put their names up, you'll have to put them up again. Actually, if you two can help me. One of the things that Anush. Yeah, I don't, yeah.
Thank you so much for,
Yes, please, go ahead.
sorry.
And
Thank you so much for very, very informative presentations. I have a question about ATT and as Canada ratified it, I'm curious, is there any mechanism which could allow civil society and non-governmental organizations to have a maybe legal case or call in some other way for compliance with the ratified treaty from the Canadian government?
How do I not? Oh,
yeah.
now it's my 1-hour lecture on the state of international law compliance in Canada. You don't ask an international law professor that question. That is not a straightforward possibility in Canada, but it is a possibility. And there have been, especially recently with respect to Israel, there have been either indications to the government of an intention to launch lawsuits, or actually some legal action that has commenced. So there are possibilities. There's not a great track record in Canada of using the courts successfully to challenge arms transfers concerns. There's no question that becoming a party to the ATT, and importantly, the fact that domestic legislation was implemented in keeping with those obligations does open up more possibilities, though.
Thank you. Yes, I have to say, as a lawyer, I find it extraordinarily frustrating that our system, that it is so difficult in our system to hold the government to account for obligations it has undertaken and which are part of Canadian law. So it's just, we have a lot of work to do. Roy's got a question at Roy Culpepper, and then I just realized I'm clearly a terrible manager of time, because it's 4:17 and we're supposed to finish at 4:15. So I don't know if I've got a few more minutes leeway. I'm begging here, but we'll have to take a few questions. So we'll take Roy's and then we'll take some of the others. And then you'll have your chance to answer as best you can. And I apologize profusely for mismanaging the time by becoming wrapped up in these two excellent speakers. Roy, please.
Thanks for those two excellent presentations. I haven't heard very much, if anything at all day about NATO. And my question is specifically oriented to Robin's presentation. How consistent is the project of common security as you outlined it? How is that compatible with the posture of NATO as we see it today? Isn't NATO in many ways a huge part of the problem we're facing in our common struggle for a more peaceful world? Thank you.
Okay, and then after this answer, then.
Yeah, okay. So many of the postures of NATO are incompatible with common security. It defines itself as a collective defense organization, but it's established, one of the quotes I used was established was with the idea of deterrence as its main vehicle for security, for safety, not no element of non-provocation. So I'm not going to get into the discussion of whether Canada should get out of NATO or whatever. There's a long debate. The popular opinion is very strong in favor of NATO. I don't think it's the point. So the immediate answer to your question is that much of what NATO does is incompatible with common security. Much of what the OSCE does, virtually all of it, is compatible with common security. In fact, if you look at the Minsk I, Minsk II elements or proposals or arrangements, this was pure common security. Everybody's involved. Everybody sits down. You discuss. You come up with they actually came up with a list of things that should be done. It wasn't implemented. So then the question is, why wasn't it implemented, and who was behind the non-implementation? So there was a common security effort. NATO, they didn't do any of that. That wasn't there. That wasn't in the cards. So a different way of approaching your question is, what do you do about the fact that NATO it doesn't have a common security agenda? What you can do is you can assure that your own country at NATO is pushing the right buttons. And for instance, calling on NATO to remove its nuclear weapons policy, in the interim to support no first use. There's all these sort of things that could be done to modify it. But one of the problems is, and I pointed this out several times before, is that look at the membership of NATO. Aside from the countries that you don't like, it's full of the countries you do like, right? So if we're going to move the agenda on common security, and many of these countries who did in the past, like Germany, the Nordic countries, South Africa is not the case in terms of NATO, are members of NATO, right? So the right countries, we need to be talking with them on the common security agenda. NATO isn't really the issue in that point. NATO is what happens when you don't have common security. Hope that's clear.
Okay, thank you very much. I'm just gonna, unfortunately, given the time here and, we're encroaching on the next panel, I'm just gonna have to go down to the next two of the people that shot up their hands right at the beginning. I think I have Anoush and Earl. And I apologize to you're pointing that someone else was ahead of you? Okay. Okay, if
So
you
I'm
think
just
someone
going
is
to-
ahead of you.
I don't want to take any more time. No, I think I'll just go quickly just so maybe we can have all
Oh, I
three of the
guess there's the
questions.
lady with-
My name's Anush Turjanian. I'm a fellow at the Human Rights Research and Education Center. And I had a question. I wanted to thank you both actually for your interventions, which are nothing short of momentous. Mr. Collins, I had a question to you about your point about your diagnostic about what I think you described as complacency and hubris, and what might be the causes for this. Because earlier in your presentation, you suggested that we can't be fighting against capitalist structures in our approach. And yet I wonder if there is an alternative framing, which is to consider that there is a deep and profound political economy to the complacency and to the hubris that we ignore at our peril in trying to problem solve. But I do want to get.
Yeah, it's a good question.
Okay, we're gonna get Earl and then we're gonna
Oh.
have fun. Okay. Thank you very much. Well,
Go,
then
go.
that means we can go to her, we can go to you, please, because clearly you're the person that I missed.
Sorry, not to take any more time, but I just had a really quick question. We talked a lot about arms.
Put the mic up.
We talked a lot about arms treaties, and I was just wondering, curious on your thoughts on whether common security frameworks effectively address contemporary global conflicts if they don't confront the historical injustices that have left former colonies economically marginalized and reliant on militarization. So by confronting this, I mean initiatives such as, reparative justice initiatives, economic reparations from wealthier countries, collaborative peace building efforts that strongly represent the global South. Just curious on that other side of the story.
And I'm going to excuse myself. Unfortunately, there's a CBC journalist outside waiting to do an interview with me, and I think both of those questions are really for Robin. So it was a pleasure. I'm coming back.
You have to remind. So hubris, 1989, end of the Cold War. So one point I want to reiterate was that the common security, the designers of the concept made a major point, which was your economic or political system is not the point of common security. Common security is about states and systems that disagree sitting down to resolve security questions. But the point that you're raising is, I believe, is that there's economies and economics involved in the arms trade and in the problems that resulted post end of the Cold War. And that's absolutely true. Now, one could have a political argument about which system would better accommodate the solutions to the economic problems that we face. The only thing that I'll point out, and I'm not making a partisan statement here, is that many of the advocate countries for common security were social democratic countries. So maybe that's a decent compromise, and for some that's heresy, but I think that points out that for another thing is that common security actually has alleviation of global poverty as one of its elements. So it's not like it doesn't care about economics. It just says that the economic system you reside in is not an impediment to your state and my state sitting down together to find out how we can become less provocative and that our securities are not contingent or are not damaging the securities of the other. So it's a roundabout way of getting to so that's why I'm saying it's not really the issue. But economics can be the issue, and economics does drive the arms trade. We were just talking about this earlier. All they want to do is make money. They don't care whether they make money in weapons or solar panels, right? So it shouldn't be an obstacle to transition the economies and the industry and so on if there's political will. That's what's missing. But also the perspective of your security is contingent on my security. The two together.
The second one is just yes.
The second one is yes. I've been informed.
Yes, it does accommodate the issues that were raised of reparative justice.
Reparative justice issues was yeah.
Okay.
As a matter of fact, you look at the OSC, you look at the OSC practice, it's significant proportions of that conflict resolution and justice message. Now, each country will give or take on that approach to justice. Not everybody likes that approach, and I've heard arguments for both sides of that argument. For instance, in South Africa, but anyway, there's bonus elements to that as well.
Thank you all, everyone, for
Thank you.
participating in the